5 years ago, my wife and I purchased a property in Santa Monica near the beach. We wanted to use it as a short-term rental property. Recently, we had some tenants who completely destroyed the suite. I do have a deposit that I always get from the renters, but this one barely covers carpet costs. What's the landlord to do in a situation like this?
Yeah, I've handled personally a lot of cases on behalf of the landlord where that's happened. It's very unfortunate. We do see where sometimes the deposit doesn't cover the damages. Fortunately, in the situation that you're talking about, it sounds like the tenant had left already, is gone.
Yeah.
So the eviction issues, there's a whole separate process in trying to evict tenants. It's called unlawful detainer. There are judges that just do those types of actions. I think fortunately for you, because the tenant has left, the eviction, trying to get them evicted, not really an issue in the case. So really it's a case about recovering some money for your damaged property. There's a variety of different causes of action. Some of the big ones would be breach of the lease agreement, right? So in the lease agreement, it's going to talk, obviously, if you've had a lawyer who's drafted your lease agreement and it's very encompassing, it's going to say something in there about, not destroying property, obviously intentionally, even negligently. There's always room for wear and tear. That's ordinary use of the property that results in some minor degradation.
Right.
But that's not the case here. I mean, we're talking about someone who's ripped things up and
Yes.
who appears to have really intentionally or negligently destroyed the real property. So you have breach of a lease agreement. You have trespass, which is a form of tort that says when you enter into another person's real property and damage it, you can get money for that. There's also causes of action in conversion. For example, if you had a painting or a TV or a sofa and they took it away or damaged it, that's another cause of action there too. Some of these causes of action, they allow for punitive damages. So that means that we as your lawyers can try to get the value that you lost, but also we could seek additional damages for the malice. Malice, in other terms, means sort of the ill will that the tenant had done. That's another legal issue, but we've handled cases where we've sought punitive damages. And that can be 1, 2, 3 times actual compensatory damages of your case. And so I would say as a landlord, you have a lot of, you want to jump on this case soon. You want to talk to a lawyer. You want to preserve your rights. And that's something our firm has done before.